Greetings, Attorney Cheshire DeBrosse here. Munitions Group, munitionsgroup.com. Go ahead and like us on social media. Go ahead and click that little bell icon if you're on YouTube. Like us. Tell your friends about us. Please continue to follow us. I know we're inconsistent with our videos, and I do apologize for that. Life gets busy sometimes, especially for me. I run a small flower farm, actually, in where I live, and this is our planting time of year. Actually, it's peonies for anybody that's interested. I know that sounds a little odd, gun lawyer having a peony farm, but you can thank my wife for that one. That farm will either keep me alive a lot longer by keeping me in shape, or it'll kill me. I might end up under a tractor, who knows. But in any event, y'all, we're here to talk today about a case, United States versus Tamori Morgan. This came out of Kansas. I've been wanting to get a video out on this. I know there's a lot of information out there already on it. I do apologize, but let me give you my take on it, at least for those that do follow me. This is a case that deals specifically with the National Firearms Act, predominantly machine guns. And this is a district court, so at the federal level, what do we call our district courts or our trial courts? And then we get into circuit courts, which are our appellate courts. And then from the appellate courts, we go up to the United States Supreme Court. And there's some other miscellaneous courts thrown into the mix from time to time, depending on the type of case it is. So this is a trial level court. This came out, this is a 2023 case number. And basically, the defendant in this case was caught with a Glock switch. For those who do not know what that is, it's basically a drop-in piece of material that makes a firearm fully automatic. It in and of itself is considered a machine gun. And they cite to the crime listed under the Gun Control Act of 1968, which is cited as 18 USC 922 subsection O as an Oscar. And it's very simple, and actually what I want to do is actually bring up the actual language for you. But essentially what it says that no one can own a machine gun. I mean, that's essentially all it really does say. But let me get the exact language so you all can see it here with me. That way we know what we're dealing with, and it's not going to search for me, so let me just scroll down here. And it says, basically, it shall be unlawful for any person to transfer or possess a machine gun, period. That's it. So what did the court say when they challenged this on Second Amendment grounds? So first off, they challenged it in two different ways. When you do a constitutional challenge and you're challenging the law itself, typically what's brought is a as-applied challenge. So as applied to Derek, why does it not apply to him? Why is it unconstitutional? It's applied to him. And then what we call a facial challenge, or just on its face, it's unconstitutional. It's applied to everybody. The court pretty quickly dismissed the facial challenge. Basically really kind of falling back on the fact that certain machine guns are in fact not bearable and therefore not protected by the Second Amendment, which the court says only applies to bearable firearms. And they cited two specifically aircraft cannon that are machine guns that can't be bared. So facially, it could be constitutional in certain instances. So they moved on then from there to the as applied challenges that applied to Mr. Morgan, and they applied Bruin. So just a little history I think is relevant for the National Firearms Act for my viewers who don't know a lot about this or someone interested or just getting into the gun industry. The National Firearms Act is essentially our very first gun regulation other than the Second Amendment in this country. It came around about in 1934, and it was a result really of the gangland wars that we were having predominantly in Chicago with Al Capone, Bugs Moran, the St. Valentine's Day Massacre, where the Bugs Moran gang dressed up as Chicago PD, gunned down a bunch of the Bugs Moran gang. They were dressed as, again, police officers. They were using what they called street sweepers or Tommy guns. So Congress acted, and there were some other things too. There was an attempted assassination of Franklin Delano Roosevelt. There was the assassination of Mayor, if I get this name correctly, Cernak in Chicago. So a lot of this stuff kind of, as is often the case with gun regulation, kind of came to a head. And we are now stuck with what we have as the National Firearms Act. And it wasn't until 1986, actually, that new machine guns could not be added to the registry. So up to 1986, you can go out and buy a brand new machine gun, pay the tax, and you can own it. And manufacturers could still make them. You could still possess them and buy them. And then 1986, with the Gun Owners Protection Act, the Hughes Amendment came about at the 11th hour of the debate on that bill, passed by, if I remember correctly, an oral vote with Charlie Rangel serving as the Speaker of the House. Please correct me if my history's wrong, but I'm pretty sure that's correct. In any event, what ended up happening at that point in time was the law basically now says no more machine guns. If it's on the registry right now, we can move forward with that, but no more machine guns can be added to the registry at that point in time. So that's essentially what the National Firearms Act is and how it was modified in 1986 by the Gun Owners Protection Act. And what that did is it obviously drive prices through the roof because now you have a limited supply. And then if you have increased demand as inflation happens and the value of the dollar is worth less, more people can afford the tax, which has never been adjusted for inflation. So you have increased demand. Limited supply, increased demand, prices balloon. So that's a little bit of the history with the NFA. So that's what we're dealing with today. The court started out by just talking a little bit about that the standard under Bruin and how it's come about, and that the government must prove that the regulation that we're discussing here, and that's 922 subsection O, must be consistent with the historical firearms regulation and tradition. This case arises again out of Kansas. It's the 10th Circuit, and the court noted that the Bruin analysis has never been applied to the 10th Circuit. Bruin is the case that came out of New York a year or two ago that basically said, hey, we don't apply what we call entrance balancing when you're attacking the law from a constitutional perspective as it deals with the Second Amendment. We apply a historical, contextual analysis. And that's why the court used the terms historical firearm regulation tradition in our country. So the government's not obligated to prove an exact replica from when the Constitution was ratified or the Second Amendment was ratified to the regulation that's being challenged, just something that's analogous, right? That's similar enough. So again, they had yet to apply Bruin, so the court went ahead and analyzed it accordingly. And they simply started with the text of 922.0, and I've read it to you. It's nobody can possess a machine gun. Because on its face, certain machine guns, again, such as aircraft cannon, can be non-bearable arms. Therefore, the facial challenge failed, as I already discussed. But a machine gun in this instance is bearable. It's something that you can, put under your coat, put in your pocket, normal machine gun, that sort of thing. So then the government started to cite to Heller. Heller is the 2008 pivotal case in Supreme Court jurisprudence with regards to the Second Amendment. I actually was graduating or had just graduated from law school when this took effect. So kind of fortuitous to my career in a lot of ways. But Heller basically said, look, Second Amendment's not a militia right. It's not a right to just the government, but it's a right to the people, to the individual, to Derek DeBrosse himself. He has this right, much like the First Amendment. And then later came out the McDonald versus Chicago case that says the states have to respect that right in the same way the federal government does, what we call incorporation to the states. So again, they cite to Heller, and the government was citing a lot to Heller in the dicta. And I remember when Heller came out, I was really upset with Scalia. I later found out, if I remember correctly, reading that Scalia's arm might have been twisted a little bit into putting this dicta in there. What maybe wasn't in the original draft, but it was put in there and basically said that certain regulations on dangerous and unusual weapons, i.e. machine guns, could be considered lawful. This is dicta. Dicta basically means it's not the ruling, it's not a holding, but it's what we would call persuasive authority that we could cite to and say, look, this is how the government was thinking. This is what is intended by this law or this statute. With that said, I always struggled with it because you really can't see a traditional machine gun is unusual in my mind. One, they've been around in the court in Kansas, in this case, notes this, for over 100 years. And if they try to say, well, they're unusual, not many people own them. Well, not many people own them because we overly regulate them, right? It's kind of a circular argument in my opinion. The same thing with being dangerous. I don't know how they're necessarily much more dangerous than just a regular AR-15, other than it can fire many more rounds at one time. But with the proper training and care, it could be not dangerous. But with that said, I was never a big fan of that dicta. So the government always cites that dicta. It's like argument 101 out of Heller. So the government cites the historical laws about people, especially coming from common law England, these laws that existed, these statutes and regs that said you can't go out and about in public with a dangerous, unusual weapon. The court went into that and said, yes, but those laws were really directed toward the intent, right? You can't go out and about in public with these weapons and terrorize the people. That's what they were getting at. If I buy a machine gun, lock it in my safe, as the court noted, and leave it there for 20 years, I'm still just as guilty under 922.0 as somebody who took it sort of waving it around at cars. So what's actually being criminalized here is the mere possession and not the intent to go out and about and harm society. So the government cited that. The court shot that down too when it was applying a historical analysis to this regulation. So basically, that's where the court came down and said, look, this is just mere possession, and as it applies to this, the motion to dismiss is granted. This is not constitutional as it's applied in these circumstances with a gentleman who bought a bearable machine gun and is not going out and about and terrifying public. It's interesting, what happens with this. I'm certain they've either have already filed the notice of appeal, and I should know this before I made this video, and I apologize for that. But if they don't, they will. I almost can guarantee that. So we'll see what happens in the 10th Circuit. The court did also note something that's interesting procedurally. That said the 10th Circuit has not analyzed a Bruin analysis yet, and in fact, they sidestepped it in a former case. If I can find the name of that case for you, let me see here. Yeah, it looks like they're quoting to, well, I can't find the case of the 10th Circuit, but they refer to a case in the 10th Circuit. Here it is, Vincent versus Garland, 80 F.4th 1197 10th Circuit, and it basically, I'll just read you what the court said. The 10th Circuit sidestepped the Bruin analysis in a challenge to the prohibition against felons possessing firearms under 18. USC 922 G1, so that's the generally crimes punishable more than a year, you can't have a gun. And the court concluded that Bruin did not abrogate the 10th Circuit's prior decision in United States versus McCain, which upheld the constitutionality of 922 G1 in the face of Second Amendment challenge. And then this court in Kansas goes on to say, nevertheless, just last month, the Supreme Court vacated the Vincent case, where, again, the 10th Circuit sidestepped the Bruin analysis, and remanded for further consideration in light of Rahimi, which was a United States Supreme Court case that just came down in June. The court interprets that as indicating that the Supreme Court means what it says. The constitutionality of laws regulating the possession of firearms under the Second Amendment must be evaluated under the Bruin framework. I agree with that. So with that said, this is good news for those of you that are out there that are gun owners, that are interested in buying machine guns. Right now, they are still regulated. Right now, those laws are still on the books, but as far as it applies to Mr. Morgan, at least in this instance, it's considered unconstitutional. Let's see what happens in the circuit court. Stay tuned. As always, I really appreciate your guys' attention to my practice and what I'm doing. I try to keep things as informal as possible for y'all. I always drop links and comments in. Hopefully, I'll get to some of those questions. There's just no way I can get to all of them, but I do appreciate the comments. It gives me ideas and things to talk about. I'll try to keep bringing current events as I can. As always, remember to be safe out there and carry on.